Good evening. The August 10th, 2017 Rent Control Board meeting is called to order. Would the secretary please take roll?
Commissioner Flora. Here. Commissioner Phyllis. Here. Commissioner Foster.
Here.
Commissioner Trosis.
Here.
Commissioner Duran.
Here.
All present.
Thank you very much. Would you all please join me in our salute to our flag?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, just a reminder to the public, if anyone wishes to address the board this evening, either on a specific item or tonight's agenda, or at the public comment section, please see the secretary and remember to fill out a speaker's slip. There was no closed session today, so moving on to item number 5, the approval of the minutes. May I have a motion to approve the minutes of the board's last meeting?
Move to approve. Second.
Okay, there's been a move and a second by a voice vote. All in favor of approving the minutes?
Aye.
Aye. Okay. And for the record, I abstain, as I was not here at that meeting. Okay, moving on. Special agenda items.
Yes, I have just a few things this evening. First of all, there are a few written communications on the dais for you from related to the public hearing on Regulation 4400. So there are 3 of those. As you know, the summer is a very, very busy time for us. During the month of July, we are busy collecting and processing registration fees. So I'm happy to report that we had 97% compliance in payment of registration fees this year. So that's great. And we've done a rebill out to those remaining 3% who had not yet paid the fees. Mm-hmm. So then after that, rent increase notices go out. So as you can imagine, August is a very busy time for us, hearing from tenants asking if the rent increase notices are correct. So I encourage anybody who has a question, either owner or tenant or property manager about the rent increase notices to please give us a call so that we can help clarify anything. One thing that I did want to mention is if an owner chooses to pass through the surcharges that are based upon the tax bill, they must include a copy of the tax bill with the rent increase notice so that the tenants can verify the calculation of the pass-through amount. And the other thing I wanted to mention is as of July 31st, the requirement is in effect that owners must provide the 2-page information sheet to any new tenants. So please do that if you're a property owner renting to a tenant as of July 31st. The vacancy registration form has also been changed to have a space that they can indicate that they provided that information to the tenants. We provided a copy of the information sheet to all of the property owners and a copy of the new registration form, so they should all have that. But if they don't, they can call our office, we'll send it to them, or they may download it from the website. So that's all I had this evening, and thank you.
Very good. Thank you very much. Okay, we're going to go into item number 7, the public comment. And just as a reminder, this is the time set aside for members of the public to address the board on matters that are not included in the agenda, but that are within the board's subject matter jurisdiction. Please note that the board cannot take official action at tonight's meeting on any matter that is not included on the agenda. Having said that, there is one request to speak. Mr. Bill Davids, come on up to the podium if you would. You have requested 3 minutes, so whenever you're ready.
Good evening. I have spoken here before. I've actually been here 6 times. I think my voice is echoing. Anyway, I'm sorry that's over-amplified, but anyway, I asked Tracy Condon to email you an article from this past Sunday's New York Times concerning the escalating rents in New York for commercial retail spaces and the 3.9% tax that New York City imposes upon those retail spaces. Now, you might be puzzled why I asked to do that, and basically I have to go back to the previous 6 reasons I've been here concerning the school bond and college bond surcharges that tenants are required to pay. In New York is dealing with excessive valuations in terms of rent, and obviously New York City is vacuuming in a great amount of money, 3.9%. on rents for commercial spaces that are now valued at hundreds of thousands of dollars, if not millions of dollars. In Santa Monica, the surcharges are being passed on to escalating valuations for property that residents live in. 2 years ago, I received a 120% increase in the school bond and college bond taxes. This past July, when we got the new increases for September, it went up another 40%. This is damaging. In New York City, people have been losing their businesses of 20 to 30 years. In Santa Monica, people are living in apartments for 20, 30 or more years, and they're now being faced with these excessive valuations and the commensurate surcharges that go along with those valuations. I think 160% increase in 2 years is terrifying. And in particular, with my building, we're nowhere near full valuation yet because it's still under construction. I am asking you, pleading with you, to do something this year concerning the surcharges that tenants are required to pay, because in New York, people lose their businesses. And here in Santa Monica, people are going to lose the roofs over their heads. Please do something this year. Thank you.
Thank you, Mr. Davids. Well, I have one request. One other commissioners would like to speak. Mr. Flora.
Mr. Davids, could I ask you a question? I see my property taxes go up for the bonds that and other parcel taxes that I certainly vote for. But these percent increases you're speaking of, that's for your building, or that's just your own pass-through for your unit?
I'm in a 90-unit building, so it's divided by 90 units.
Okay.
So basically, it's gone up 160% per unit. Not
unit.
per building, but per unit.
Okay. Can you give a dollar amount that's
Yeah,
gone up for you personally?
yeah.
To put it in dollar terms?
3 years ago, it was $18 when it was under the previous owner. Under the new owner, under the new ownership, it went up to just roughly $40. Again, remember, it's divided by 90. This year, it's $56. Again, divided by 90, meaning that
This is per
unit.
per unit per year?
Per year.
yeah.
No, it's per. I'm sorry, it's per month.
That's what I thought.
Yeah,
That's what I
per
thought.
month. But basically, it's divided by 90. But it's per month. I'm sorry, per month.
Thank you.
I also have one more speaker.
Mr. Davis.
Commissioner Foster, one more question.
Could you clarify for the board and for the public, is your reasoning that it's because your building sold that this is occurring? You didn't preface your comments.
Oh, I'm sorry. The building was sold back in 2015. In July of 2015, we got notice that the building had changed hands. And this is a result of the valuation that was put on the building when it was sold. The original valuation of the building was $15 million with the LA County Assessor's Office. The building was sold for $45.6 million back in 2015, and this is based upon the assessment from 2015. We received a tax assessment from something that's known
Thank
as...
you. That's.
okay.
I
Sure.
just wanted to clarify that.
Thank you.
That
I just wanted
you were
to be as
insinuating
specific as possible.
I was
Yeah.
wondering if you were because your building had turned over,
Yeah.
it had changed. Just to make it clear for the public. Thank you.
Exactly. Thank you.
Mr. Davis, one more. Commissioner
sorry.
Phyllis has one
I'm
question.
sorry.
So without launching into discussion, Mr. Davids, I want you to understand this is something the board is aware of and concerned about. At the same time, I think we have to be precise about what exactly is causing these increases and the specific dollar amounts that are attributed, for example, to the bonds as opposed to property taxes, which are, I would estimate the parcel tax is going to be the most sizable amount because that's what was most significantly affected by the valuation. Is that correct?
Well, and from my reading of what was passed along to us, the most sizable amount was the college bond and the school bond.
What were the dollar?
You know,
dollar
I
amounts for
didn't
that?
take the page, so I don't want to mislead you right now. But
Okay.
basically, the substantial amount went to the college bond and to the school bond.
Okay.
Yes, the bonds are affected by the value of the property. So
Yeah.
when the property sold for 3 times its previous assessed value, those bond
gonna
values
go up
went up 3 times as much. The parcel tax is the same, so the parcel tax stayed the same upon the sale, the
Okay.
school parcel tax. But it's the bonds that are affected by the increasing values of the property.
So it's only the bonds that are driving up the.
Primarily the bonds, yes. And then there's also the amount of the bonds. The factor changes from year to year depending upon what bonds have been issued. So there are various factors that impact that any given year. But the sale of the property is the primary thing.
Right. I mean, right. But so I know that this board supported, unofficially, I believe, the new college bond
Yeah,
measure.
I think we need to.
Did we? Did we not do that? I thought we did. I thought Denny came to this meeting. Okay, Carolyn. But I thought Denny came to this meeting and asked for us to support. Am I misremembering? So this is.
I don't remember specifics, but I would say that I think we're entering into discussion about this item, and it's not on the agenda. Maybe we could make it as agendize it if we want to discuss it further or talk about.
Maybe you could give us direction on how you'd like to attend.
Okay. Commissioner Phyllis, do you have any other questions then for Mr. Davids?
Not for Mr. Davids, no. Thanks.
Okay.
Thank you.
Thank you, Mr. Davids. We received, it wasn't exactly late, I would say. Ms. Elaine Golden-Gieler asked to speak in the public comment. She was filling out the form before I requested. There is a PowerPoint that she wants to present. So I do not object to it getting set up and watching it. Does anybody else object to that? Go ahead.
Sure, but can we ask staff, can we direct staff to do something at the end of public comment or no?
Why don't
We
we,
can do it now.
I just would like
can
more
direct it
information
anytime.
on options for pass-throughs. Again, to address your comment, it is something we've discussed quite a bit with members of the public offline and amongst staff. So I would like potentially the beginning, a report back on options and best practices from other jurisdictions regarding pass-throughs to tenants. And then we can take it from there.
okay, hearing no objections to my request, it's fine to start the PowerPoint. Ms. Golden-Gieler, you have requested for 3 minutes, so whenever you are ready to begin, feel
Thank
free.
you. There was a lot of traffic tonight. They have a concert. Try to get here.
It is a
Should have
season.
left around 5 o'clock. Anyway, I hope that City TV will be listening and will show my PowerPoint rather than myself. I'm giving them a chance to do that. Okay, first is what I learned at the July Rent Board meeting, which was last month's Rent Board meeting. I learned that the Rent Board has broadened its jurisdiction over non-rent control issues. The Rent Board General Counsel warned that landlords may resort to schemes that other industries have used to defeat price controls. For example, in World War II, bakers added sawdust to flour, making candy bars smaller. The price remained the same, but the product was smaller or not as good. The Rent Board to the rescue. Now the Rent Board will randomly weigh your Big Mac, check for excessive gluten in your Wheaties, make sure there's a toy in every Cracker Jack box, and monitor the size of matzo balls at Izzy's. I learned that the Rent Board is considering an express line for any tenant who files at least 10 Rent Board decrease petitions. I learned that if a landlord harasses a tenant, the city attorney provides free assistance, but if a tenant harasses a landlord, silence, crickets. At every city meeting I attend, there are speakers promoting no smoking anywhere or anytime. Here are 2 of their recent comments. Yuck. Your toothbrush may be covered in third-hand smoke, which is even more dangerous than second-hand smoke. Owners should tear down apartment walls to the studs to remove third-hand smoke. I also learned the Rent Board may hire a consultant to find applicants to fill some job openings paying over $150,000 per year, including benefits. I learned that the Rent Board creates barriers for job seekers by announcing the opening with only a 3-day notice. I have some ideas the Rent Board can use to increase the number of applicants for the hearing examiner position. Number 1, explain to the potential job seekers that there is no legal research required. Number 2, tell them not to worry about defending their decisions. The landlord always loses. Number 3, and what is probably the best way to get more applicants, have a city TV blackout of all rent control meetings. Thanks for watching.
Thank you, Ms. Golden-Gieler. All All right, there are no more requests to speak, so moving on to item number 10, jurisdictional items. And the first one, oh, sorry, there's a request to speak, Commissioner Phyllis. Sorry, I didn't see you.
Thanks, Commissioner Duran. In light of the considerable public interest that we have regarding public hearing items 11A and B, and given that the jurisdictional items A, 1, and 2 are really clear, I think very clear cut, at least from my perspective, in terms of qualifying for the owner occupancy exemptions, I would move that the board grant the exemptions by consent for items 10A, 1, and 2, so that we can move on to item 11, please.
Third.
There's been a first, a second, and a third. First and a second, okay. Can we have a roll call vote?
Commissioner Flora,
Yes.
Commissioner Trosis,
Yes.
Commissioner Foster,
Yes.
Commissioner Phyllis,
Yes.
and Commissioner Duran.
Yes.
Motion carries.
Okay, moving along to item number 11. The board will now hold a public hearing to consider whether to amend Regulation 4038 respecting rent decrease, the post-decrease rent restoration, timing, and procedures. We'll begin with the staff report summarizing the issues and including any recommendation.
Good evening, members of the board and members of the public. These proposed regulations amendments to Regulation 4038 would do three basic things. First, they would eliminate the retroactivity of hearing examiners' rent restoration decisions, making rent restoration prospective to the same extent as rent decrease petitions. Just to provide some context for the public, if there is a hearing examiner decision decreasing rents and the landlord then remedies whatever the problem was on which that decrease was based, the rent is then restored. This regulation deals with the process for restoring the rents. Second, it would provide a more streamlined rent restoration process. And third, it would make hearing examiners' rent restoration decisions appealable to the board, which they are not currently. The occasion for making these changes now was the board's direction earlier this summer to amend the regulation substantively. Specifically, the board expressed surprise that hearing examiner decisions restoring rents are not subject to appeal. The board also expressed concern that while rent decrease decisions are prospective only, decisions restoring rent are retroactive to the date when the landlord corrected the condition on which the decrease was based, which sometimes creates a material financial burden on the tenants when there's a significant delay between the correction and the decision. The board directed staff to correct both of these problems, and the proposed amended Regulation 4038 does that. The drafting of the proposed amended regulations followed a months-long process involving staff from the hearings, legal, and public information departments, as well as the board's executive director, guided by comments from the board at its previous meetings. The proposed amended regulations' first three subdivisions, A, effective date, B, effect of reversal or modification on appeal, and C, duration, are substantively identical to the existing regulation. The substantive changes are all in subdivision D, titled restoration. Paragraph 1 of subdivision D creates a more formalized process by which a landlord may seek to have previously decreased rents restored, and paragraph 2 describes what a tenant must do if he or she wishes to challenge the restoration. Paragraph 3 describes the process by which the hearing examiner will make a decision about whether to restore rents and clarifies that it is a new decision, not a mere addition to an earlier decreased decision. But paragraph 3 also recognizes that in the vast majority of cases, the question of whether the landlord has done what is necessary to restore a tenant's rent is uncontested and easily decided. It is for this reason that the amended regulation allows for decision based on the parties' written submissions, supplemented by an independent inspection if necessary. Only if that information is insufficient to allow for a decision will an in-person hearing be held. As noted previously, a decision restoring rents is retroactive under current Regulation 4038. Under the proposed regulation, it is prospective, consistent with the prospective application of the original rent decrease decision. The proposed amended regulation also, for the first time, makes restoration decisions appealable to the board. Consistent with the idea that a party should not be permitted to appeal a decision without having first participated in the underlying proceeding, the proposed amendment forbids an appeal to the board by a tenant who did not challenge the landlord's compliance claim when it was pending before the hearing examiner. Thank you.
No.
Thank you very much. Okay, we have requests to speak. Before we go there, I'd like to ask if the board has any clarifying questions for council. No? Okay.
I actually do.
Okay.
Yes. Stephen, can you tell us how what is being proposed here compares to what's done in other similarly situated rent-controlled jurisdictions?
Yes, this would bring us into conformity with what happens in other rent control jurisdictions.
Okay, thank you.
Okay. Our first speaker, we have Mr. Jacobson. You've requested 5 minutes. Whenever you are ready.
J.L. Jacobson, 2812 Santa Monica Boulevard. I think that before exploring what other jurisdictions are doing about rent decreases in restoration, the staff, which has a majority of, it's not the staff, but the board, of which a majority of the members are attorneys, should take a look at what the Santa Monica rent control law requires. Section 1805 D14 states, and I quote, "Decisions decreasing rent shall remain in effect until the board finds the landlord has corrected the defect warranting the rent decrease." Final sentence. "Upon determination of compliance, the landlord shall be entitled to reinstatement of the prior rent level retroactive to the date the landlord corrected the defect which warranted the decrease." So, you're supposed to make it retroactive to the date the landlord corrected the decrease. Now, there's no mention of the Santa Monica rent control law in the staff report. It's amazing. In fact, the staff report says that they want to do the opposite of what the rent control law does. Here I quote again. This staff report, quote, "Eliminate the retroactivity of hearing examiners' rent restoration decisions, making rent decrease restoration prospective to the same extent as rent decrease decisions." Now, wait a minute. The rent control charter, which you're supposed to follow, says you're supposed to make it retroactive to the date the landlord corrected the decrease, and the staff report doesn't even mention that. Now, I also have to suspect the facts for the staff report because it says this item was initiated by the unanimous direction of the board after receiving communication from a tenant about retroactivity, which occurred months before the decision finding compliance was issued, caused a financial burden. Now, another thing that attorneys might want to find out who work on the board is, what does the existing regulation say? What does this mean that a compliance occurred months before the decision finding compliance was issued? In other words, the landlord fixed it but didn't ask for compliance. How is this possible? When your existing regulation, 4038, says the following: if the landlord requests compliance more than 60 days from the date of correction of the defect or condition which warranted the decrease, the landlord shall, upon determination of compliance, be entitled to reinstatement of the prior rent level retroactive to the date of the first payment, after filing the written request. So in other words, if a landlord delays any more than 60 days, then the decrease is not reinstated based upon the date of compliance, but on the date that the landlord filed. Now, they try to do a bait and switch with this new regulation at the new 48D4, and isn't it convenient that the old 4038, the existing regulation, is not before you? Now, in the new 48D4, a landlord may be collecting restored rent conformity with the hearing examiner's decision on the first rent due date occurring at least 30 days after the decision is issued. So you're not doing it retroactively, and you're not going to do it based upon the date that the landlord files for compliance. You're going to say 30 days after the hearing examiner issues a compliance report. Now that is so far from what the rent control charter amendment tells you to do that it would be subject to a facial challenge. And there have been 3 decisions about rent decreases in Santa Monica, and I was involved in all 3 of them to differing degrees, that tell you what to do. And there should be an analysis of what the rent control charter tells you to do and what you propose to do. Now, nobody minded too much if a landlord didn't file a rent compliance report and the tenant had to go back 60 days. Okay, boards of the past solved that problem. So they already went beyond what the rent control law permits by saying you can only go back 60 days. You wait more than 60 days, then we're going to base it on the day you file. So I wish you'd follow the Santa Monica rent control law. Thank you.
Thank you, Mr. Jacobson. Yes, go ahead.
Well, I would
Counsel.
just say, I'm as embarrassed as I am to admit it, Mr. Jacobson is absolutely right about the provision in the charter concerning retroactivity. At no point had I ever noticed that. I was focused only on the regulation. So I recommend that the board table this item for now and not adopt the proposed amendment.
Okay. So then that would require a motion at this point? Council, could you give me direction on that? Or can I just direct that we tail this and move on to
You
11?
don't have to do a motion. You can if you want to.
I'll move.
Okay.
Move that we table the item for reconsideration.
Okay, there's been a first and a second by Commissioner Foster to table this discussion for a later date based on recommendation by council. There were, but I believe that it would probably be appropriate to
Probably
wait for
moot.
the changes before because they would just be moot at this point. And so, well, wait a minute, there's been a first and a second.
So we have to vote.
So yes, we'd have to vote on the motion presented by Commissioner Phyllis.
And anyone who came to public comment this evening would be able to come to our next public
Well,
hearing.
Could,
I mean, but I think the crucial, like the crucial component of this is that this is not going to be the regulation that we're going to amend and or that we're going to adopt, and it's more helpful to have written feedback from members of the public between now and that time. You know, to the extent people want to influence the regulation drafting process, I think that would be more helpful than public comment now based upon a proposed regulation that needs to be reconsidered.
Agreed. And there's been a first and a second. So do we do a roll call vote or a voice vote? Okay, a voice vote is
Do you want to
fine.
speak to the motion?
There's been a first and a second. Is there any discussion?
I just wanted to say that if it's only 1 or 2 people and they've taken their time out of their evening, if they're not speaking to anything with retroactivity, is there any real harm if they can't make it the next time?
No, because I think because we're not voting on the item today, it would be a moot discussion.
Got it. Okay,
And
sorry.
we can talk about it at the next hearing. Okay.
Yeah.
So there's been a first and a second. All in favor of tabling it as proposed by Commissioner Phyllis? Aye. Any opposed? Any abstentions? Okay, the item's tabled for a future hearing. All right, moving on to item 11B. May we begin with a staff report summarizing the issue and including any recommendation?
Yes. This is a proposed regulation amendments affecting regulation 4400, which relates to construction-related rent decreases. I have a PowerPoint presentation that I'll be presenting that goes through the proposed amendments. But before we get into that, I want to just talk more generally about the subject matter. First, it's important to understand that this is not a new regulation or a new subject matter. The board has had a regulation that has been in effect governing this subject matter since 1999. It's important to understand also that even in the absence of that regulation, the board has the ability and has had the ability for the entire existence of the rent control law to grant rent decreases arising from impacts resulting from construction. The charter gives the board the ability to grant rent decreases when housing services are interrupted or when there is a failure to perform required maintenance and inadequate housing services, et cetera. The existing regulation doesn't give the board any new powers that it doesn't exist under the charter, and the proposed amended regulations also give the board no new power that doesn't exist under the charter or indeed under the existing regulations. The changes that are proposed are relatively minor and targeted based upon discussions that the board has had in the past, and I'll get into them. And before we get into the details of what is in the regulation, I want to discuss what this is not. This is not, as I said, a new law or set of regulations. This is not anything to do with earthquake retrofitting. Earthquake retrofitting is necessary construction that, if done in an unreasonable manner, will not give rise to a construction-related rent decrease. We've received a lot of communication from people concerned that this is a process that's intended to force landlords to suffer rent decreases because they're doing what the city requires them to do with respect to earthquake retrofitting in the future. That is not the case. Again, if they're required to do the work, then it's necessary construction, and it is not subject to a rent decrease under the existing regulations, the proposed new regulations, or indeed under the city charter. The board will consider issues concerning earthquake retrofitting in the future, but that will relate to the pass-through of costs. That will not relate to this issue. This is also not a legally problematic or controversial subject matter. The Court of Appeal has already upheld existing regulation 4400, and none of the proposed amendments are outside of what the court has already upheld. All right, with that, now that I've said what this is not, I'll get into what, in fact, it is. The proposal suggests 4 basic changes to existing Regulation 4400. The first is an elimination of a provision saying that the administrator acting on the board's behalf can initiate rent decrease petitions. I referred to an earlier Court of Appeal case in which Regulation 4400 was upheld. It was upheld with the exception of that. So it has never been the case that the administrator has the ability to initiate those petitions. It just was never excised from the language of the regulation, but it's not an active thing. So we've, as a part of cleanup, eliminated that. The proposed regulations also make clear the extent of mediation confidentiality, which is governed by state law. That's not something that we are doing ourselves. And it also says that when the parties reach an enforceable agreement about how they're going to handle construction impacts, that can be forwarded or will be forwarded to appropriate city staff for an amended means and methods plan. That is also not something that is in any way at odds with state law, which allows, which is an exception to the confidentiality for agreements that the parties intend to be enforceable. You may remember about 2 or 3 months ago, city staff was here talking about things that they thought would be helpful to them in dealing with the means and methods plans. And one of those things was knowing from the board when the parties, as a result of a board mediation, have agreed on what they're going to do about something so that the city can incorporate it into a means and methods plan, and this simply codifies that. The third thing that the proposed regulation does is require that all construction decreases compensate affected tenants from the date when the construction-related problems first began. Currently, the beginning date of any valuation period is the date that the board itself sends notice to the landlord saying we're aware of this construction going on. Finally, it codifies existing board practices respecting notice to the parties and hearing procedures. The proposed regulations also include a number of non-substantive changes to enhance clarity. For example, we have, whenever appropriate, used the active voice, especially when describing an action that a specified person must take. I've given an example here on the PowerPoint from proposed regulation 4400 F1A. Quote, immediately upon the board's receipt of a petition under this section, the hearings department manager must determine whether the petition is complete. So that's in the active voice. We've used the passive voice when emphasizing an action that will occur rather than who has to do that action. An example of that is regulation 4400 F2, which says, quote, a petition may be amended before or during the hearing, unquote, where the focus again is on what's happening, not who has to do it. We've also proceeded from the general to the more specific in inverted pyramid fashion and use a conventional structural division convention that's usual for currently we do not follow a consistent structural division convention. Whenever we have to amend regulations, we're just conforming them so that they're all the same and easier to cite. All right, with that, we'll get into the actual changes that are proposed. Up on the slide here, I don't expect anybody to read that language on the slide. It's in the packet and it's available for the parties to see. It's also been on the board's website. We are proposing no substantive change to the statement of purpose, just making it more concise. We received a letter from Rosario Perry expressing a concern that he believes that the regulations as proposed could be interpreted to allow construction decreases that are not caused in any way by the construction impacts rather that are not caused in any way by the landlord. That certainly is not the case, has never been the case, wouldn't be permissible under the city charter and is not intended here. But in order to eliminate any doubt, I would propose further amending the proposed language in A to add, at the very end of it, right now it says the purpose is to allow a process for construction-related impacts. As a result of construction, I would add comma, within the landlord's knowledge or control, which is the language that we use elsewhere in the existing regulation. Just to clarify that that's the case. That is, in fact, the case. There's no point in not being clear about that. The second section that's changed is a new subdivision B, as in boy. It's entirely new. At the last meeting, the board suggested that we include definitions, and we've done that. The first definition is to the meaning of the term construction, which is not new, it's elsewhere, but it's now put in its own definition section. Construction is defined as, in addition to building new structures or adding existing structures, construction includes repairs, rehabilitation, maintenance, or upgrades. Second definition, necessary repairs and maintenance. The issue there is what is necessary. It's defined as repair or maintenance. It says that it's necessary if it's required to comply with a government order, to comply with a building, housing, or health code, or to maintain the property in good repair. As to that last phrase, or to maintain the property in good repair, we had a number of discussions with staff that suggested that absent that last phrase, the definition would be too restrictive because there are a number of things that might be necessary to make a property, to maintain a property in good repair that don't amount to a violation of any of those code sections. And if there are specific questions about that, Ms. Regalado can answer them. The third definition is the definition of property, which is not specific to this regulation. This is the same definition that we used in the charter. That is contiguous parcels under common ownership. So that if an owner is doing construction on one property and owns the next door property, it's all one property, and the construction impacts going from one parcel to the other parcel could result in a rent decrease if it's a single property, because the two parcels are under common ownership. Fourth definition is what is a substantial reduction in the housing service. It's defined as a reduction that, if in view of the reduction, the landlord is providing the tenant less than was provided when the initial rent was established, to such an extent that the tenant's rent has become excessive. The fifth definition is unavoidable construction impacts. That is defined as interference with the housing service or other impact resulting from construction. It is unavoidable if it would be impossible or impracticable to conduct the construction without causing that interference or impact. That is not much different from a basic dictionary definition. That's not a term of art. Finally, we have defined the term uninhabitable, and a unit is uninhabitable if it fails to substantially comply with specific statutory habitability requirements, or if it's affected by odors, dust, debris, vibration, or other impacts sufficient to constitute a nuisance under California law. So that is the only entirely new thing that has been added in terms of a section. Here you can see the difference, just sort of visually, between existing subdivision B, as in boy, and what would now be, under the proposed amendment, subdivision C. It's the same subject matter, it's just relettered because of the addition of the definition section. This would just do two things. One is substantive and one is not. The one that is not substantive is it eliminates the little Romanettes, the lowercase Roman numerals that identified some structural subdivisions, and replace them with 1, A, B, and C. And it also eliminates the requirement that a housing service be interrupted for 24 hours to warrant a rent decrease. Oh, sorry. I haven't gotten to that. Yeah. Okay, moving on to the next proposed change. You can see up there the existing subdivision C, and next to it the new subdivision D, which is the same subject matter. This clarifies that the board will send notice to landlords upon knowing that there's planned or ongoing substantial construction, regardless of how the board finds out about it. Second, it eliminates the date of the notice as the earliest date for which construction impacts can be compensated, consistent with the intent of the entire duration of construction impacts be compensated for. I'm sorry. Let me just move back to the previous slide. In the proposed new subdivision C, under paragraph 1, subparagraph C, it currently says, as proposed, the construction interferes with the tenant petitioner's ability to occupy the controlled unit as a residence. I recommend adding the word substantially, so a construction substantially interferes with the tenant petitioner's ability. That's not really, that's simply clarifying. It's consistent with what's already in proposed subdivision A, the purpose, which specifically says that it has to be substantial, but again, there's no point in not being absolutely clear for the benefit of everybody who has to interpret this regulation. All right. Here you can see the existing subdivision D, and next to it, the proposed subdivision E. The changes here concern mediation. The first proposed change is to allow lawyers to participate in mediation. As explained in the staff report, it has been staff experience that lawyers are often very helpful in helping the parties reach an agreement. And to the extent that there's a worry about the imbalance of powers between a represented party and an unrepresented party, that can be dealt with by a skilled mediator of having the parties be in separate rooms or some other situation in which the power imbalance doesn't come into play. It also clarifies the extent of mediation confidentiality, as I discussed before at the beginning of the presentation. Next, you can see here the existing subdivision E, and next to it, the proposed subdivision F, which deals with the same subject matter. This eliminates the purported right of the administrator to initiate a petition, as I mentioned earlier, as is required by Ocean Park Associates versus the board. It also includes a new requirement that a petition may not be filed unless there is at least one ongoing impact. As explained in the staff report in greater detail, if a construction impact has happened and the building is fully cleaned up and everything is fine, it's almost impossible for the board to fairly evaluate, or the hearing examiner to fairly evaluate what the construction impacts were, because there's no means of verifying them in most cases. Moreover, if we're only talking about prospective events that have not happened, and there's not even an existing set of facts that allow the parties to talk about, or the hearing examiner to evaluate how that construction is likely to occur, it's difficult to fairly evaluate how that should be valued. So the parties can wait until the construction begins as proposed in order to apply for that. They're not prevented from applying. They just have to wait until the some construction impact begins. This does not require that they can include in their petition only those impacts that are currently existing. It's just that there must be some impact currently existing in order to file their application. Here you can see the existing subdivision F, and next to it, the proposed subdivision D dealing with the same subject matter. This clarifies that the hearings department may coordinate or consolidate cases for administrative convenience. This is something that that staff already does. It has two benefits. One, it allows the process to move much more efficiently to get to the results so that the parties have some certainty as to where they stand. But it also allows settlement and mediation to be much more effective. If the issues are all consolidated together, the parties can more effectively resolve all of the issues globally. We have found that has been very helpful. Next, you can see here the existing subdivision G, and next to it, the proposed new subdivision H dealing with the same subject matter. The changes here are really just structural. The text is broken up into smaller chunks rather than, as it is now, long paragraphs that are somewhat difficult to read. There is one substantive change, and that is the addition of a new valuation category for displacement, which doesn't, it is currently a basis for a decrease. It just wasn't codified with a decrease range amount. Also, and I wouldn't really characterize this as substantive, the decrease amounts are updated. The updates, though, are just consistent with the updates that the board enacted after a public hearing for regular rent decreases. So we're just updating the regulation so that we don't have two different sets of valuations for the exact same things. Next, you can see existing subdivision H next to proposed new subdivision I, dealing with the same subject matter. This retains the existing rule that a hearing examiner can order a rent decrease from the rent actually paid, even if it's lower than the MAR. A person looking at this set of regulations or this regulation would not know that that was what the subdivision deals with under the existing regulation, because the heading is discretion of the hearing examiner and board. So we're proposing to change it to decreases from less than the maximum allowable rent, because that's what the subject matter of this subdivision is. Next, you can see existing subdivision I next to a blank space. This eliminates a redundant statement that the decrease may be from the onset of the impacts, because that is already said elsewhere. We don't need to say it again here. It also eliminates the statement that a decrease may be only from the date when the board sent the notice to the landlord, because that's contradictory to the idea that decreases are from the onset of the impacts. Here you can see a very long and very really impossible to read on the screen, but easier to read in the staff report, side-by-side juxtaposition of subdivision J, and there are no substantive changes to this. This is simply reordered to break up the text into smaller chunks and include subdivisions and make it easier to read. The next is a new subdivision K next to a blank space for the existing regulation. This is not new substantive matter. This merely makes a new subdivision of matter that was removed from the previous section because the previous subdivision explains how to calculate the value of a rent decrease. And in contrast, this subdivision explains how the rent decrease, once the value is calculated, affects the monthly rent. So this is rather than have these two different subject matters in one subdivision, we've just divided them out into two subdivisions. This is existing subdivision K and proposed new subdivision L. There are no substantive changes here. This is just a reordering to make it easier to read and understand. And that is true with the last two sections too. The existing subdivision L is titled Addendum. The proposed new subdivision M, as in Mary, says modifying the decrease, which is what the subject matter really is here. And there are no substantive changes to this either. This is consistent with what the regulation already provides for. Finally, there is the last subdivision, which says that the remedies provided by this regulation aren't exclusive. They're cumulative with any other remedies that the parties may have, and there is no substantive change to that either. All right, that concludes my presentation. Thank you.
Thank you very much. I have several requests to speak. Oh, I see. I have a Commissioner Flora. Before we begin, is that for deliberation now, or do you have a clarifying question?
Oh, I've got several, but I can hold.
Okay, thank you. Gotcha. Put yourself back. You can put yourself back in, then I'll see you're on first. Okay, we have J.L. Jacobson, excuse me, has requested 5 minutes. Whenever you're ready, Mr. Jacobson.
The light's not on. Oh, there it is. J.L. Jacobson, 2812 Santa Monica Boulevard. I'm amazed to hear that the Ocean Park Associates case is touted as a victory for the Rent Board's construction regulations. The regulations were passed in 1999. The Ocean Park Associates case was rendered in 2004. I wrote the first draft of all the papers in the case. Let's look and see what the case actually said. The case referred to Charter Amendment Section 1805C. Upon receipt of a petition by a landlord or a tenant, the maximum rent of individual controlled rental units may be adjusted upward or downward in accordance with the procedures set elsewhere in this section. So, a landlord or a tenant initiates the process. And from the Ocean Park Associates case, 8 Cal Reporter 432, sorry I don't have the Cal app. The rent decreases at issue here are governed by Section 1805C, which gives the board the power to act upon receipt of a petition by a landlord or a tenant. By promulgating Regulation 4400, the board has taken the position that 1805C authorizes it to initiate petitions for individual rent adjustments any time a construction or problem appears to affect 2 or more units. The issue is whether the board has reasonably interpreted the governing ordinance, and the court found it did not. I continue. Quote, in our view, the words of the RCCA, that's the rent control law, are clear. Requests for individual adjustments are to be initiated by the landlord or the tenant, and the board's power in this area is limited to formalizing rules of conduct for individual rent adjustment hearings. Now, the staff report here says that you're going to require that rent decreases due to construction impacts be calculated from the date those impacts first arose. And actually, the regulation doesn't even do that. Well, let me tell you what the regulation says. It says that 4400D notice, upon receiving information from any source, like the Building and Safety Department when an owner files a building permit request, that's how it's been applied in the only letter I saw. Substantial repairs, rehabilitations, or upgrades that are planned or in progress. So, when you get a notice that construction is going to be taking place, you're going to start the time running before any tenant files a petition. That's not what the Ocean Park Associates case. And then you take the tenant out of the thing completely by saying this at 4400 D2. Okay, first of all, it says that the rent board will inform the recipients that the board may grant rent decreases for disruptions, and the only notice a landlord must be given before a tenant may file a petition, this is the only notice the landlord must be given. Now, when a tenant files a rent decrease petition, any other kind, the tenant has to give the owners 30-day notice to make a correction. And then it goes to mediation, so the owner has a chance to make the correction, so there's no hearing, there's no litigation. Here, you want to speed up the process just before all the retrofitting requirements take place. So instead of the tenant starting the process by filing the petition, the board starts the process based upon information from any source, like the Building and Safety Department, like the permit department downstairs. You put the landlord on notice so you can make the rent decreases retroactive. And I'd also like to point out that the issue of basing rent decreases based upon the condition of the tenant has never been upheld. And it says here, decreases for specified conditions, H1 or D1, whether the petitioner works at home, whether the petitioner is customarily at home, whether the petitioner provides care for others in the home. So now we're shifting from preserving the housing stock to giving compensatory damages for tenants who are at home during normal construction hours. That was never upheld. You've got 3 decisions about rent decreases. They're published decisions. Nothing justifies what you're doing in this case. Thank you.
Thank you, Mr. Jacobson. We have another speaker, Shruti Shankar, and you have requested 5 minutes. Okay, and just so you're ready, the person speaking after Ms. Shankar is Marilyn Alexander.
Excuse me if I could just, Ms. Shankar, do you live at 1238
Yes,
10th
ma'am.
Street? Ms. Shankar has a petition that's pending before the board, and
Yes,
so I
ma'am.
would remind you that it's not appropriate to talk about the specific conditions at your
I was
property.
informed at the
Okay.
beginning of this.
All
hearing. But I do want to state that, one of my fellow tenants recently stated that we're living in a new form of harassment because, I've lived here since 2005 in the same building, same unit. There was never any construction going on. A new owner came in. They offered buyouts just like you normally do, and then they filed construction petitions with the city. They got their permits, whatnot. But the permits were for an entire overhaul, and we tenants went from being 20 to 4 only left of living through this construction. And none of us knew what the rules were. Everyone's scrambling, everyone's making contacts with city officials. So when you say that, you know, our petitions got put in, you know, like maybe a month or 2 months after the construction started, I agree with this statement that's saying that it should start when the construction started, because if you're living in naivete in the city and you don't know what the rules and regulations are, it's going to take you a minute to catch up. Even today I came in, I didn't know what I was supposed to say. I didn't know what the rules, regulations were. I don't know what I cannot say, you know. So for someone that's just kind of living innocently in the city, I think it is very good to have, you know, have that time to catch up and be able to learn what's going on. And so, you know, if construction started August 1st, but my petition didn't go in until November, I feel like I would have been robbed all those months of not being able to bring in evidence going back to August, or whatever else that needs to go back to the beginning of this to build my case. And then, I'm sorry, I'm just nervous. And as far as mediation and having lawyers there, luckily I have awesome neighbors, and we all kind of bonded together, and we all talked, and we all supported each other, and we represented ourselves as a unit. But I feel like if it's just me alone, it would have been nice to have some legal counsel, someone kind of guiding that. So I think that would be something that would benefit people in the future. And then I have a question about the earthquake retrofitting versus construction retrofitting, because what if an owner doesn't take the opportunity to earthquake retrofit while they're doing construction work? Because the two are not necessarily exclusive of one another.
Well, you can ask your questions to our staff on the side, but for right now we can't answer questions to you. But you can make comments.
Okay.
And we've taken that as one of your comments.
Okay.
And we recommend that you talk to Ms. Condon afterward if you have specific questions about the distinction between construction related and earthquake retrofitting. I'm sure.
No, I understand the difference between the two. What I'm suggesting is that what if an owner comes in and does all this construction work in the building, but they don't bring it up to earthquake code, so then a tenant is then displaced twice.
I think they can do that.
Well,
right?
Yeah. Why don't you talk with Ms. Condon?
Yeah, I don't know. I take that back.
And there's nothing in here about like relocations and how soon relocations can be granted. Is that something that's part of a different code? Okay.
Yes, go ahead, Ms. Condon.
Relocation is part of the city's municipal code, so that is enforced by city agencies, not the rent control agency.
Okay.
The relocation piece.
Okay. Well, apologies. I think that's all I have to say today, because I was prepared to speak one direction and then kind of adjusted what I had to say. But thank you very much for your time. Appreciate it.
Thank you very much. Our next speaker is Marilyn Alexander, and you've requested 5 minutes. And after Ms. Alexander, we have Jay Johnson.
I just want to thank you. I came here mainly to be educated today, and I have gotten educated, and I had very good, I had very good counseling when I came to file a petition for a rent decrease, and feel pretty complete about that. So I'm just look forward to the process, and I've been advised, not to get specific. So thank you very much for your work.
Thank you. Okay, Mr. Johnson, you're next. You've requested, I believe, 5 minutes. After Mr. Johnson, I have Lori Brown.
Where is the button that raises this up? It used to be here. It's up as high as it goes? Very good. Greetings, everyone. I came tonight primarily over the concern of retrofitting. Now, staff has simply explained at the beginning that the proposals before you tonight pertaining to 4400 basically do not address and do not pertain to the retrofit issue. Well, it's the big elephant in the room, as they say, and there's a lot of anxiety going on, as I'm sure you're all aware over the last year or two in the city, between the tenants who say, am I going to have to pay for all this? And the property owners saying, am I going to have to pay for the whole thing? There's a lot of I would say, lack of information that's out there. So the first thing I would do as to 4400 is include some kind of a preamble or an introductory cover page of some type when we're putting out decrease petitions that it does not apply to retrofitting issues, if I understood the explanation. However, I can foresee a number of cases where after the retrofitting is done, there are issues that some tenants would feel that, on the one hand, since they lost a garage door as an example, and that the garages now are for basically parking of vehicles rather than the storage they have, it opens a Pandora's box. And I just think we should be clear on that. And that's why I would just like to repeat to you what I've said earlier, because it may or may not come up. Pursuant to the shared burden, and I want to use the word shared all the way through, and this is a theme I think the city and the rent board from a public relations point of view is very critical to put out there. The shared responsibility of both landlords and properties owners, the tenants in the city, as well as city official and staff. The shared responsibility, it's not an all one way or the other, but pursuant to the shared burden of property owners and tenants during the legally required earthquake retrofit construction, and pursuant to the Golden Gateway San Francisco decision dealing with substantial interference with habitability, please consider the following proposal. Proposal number 1 regarding 4400. During the required earthquake retrofit construction, the filing of rent decreases for loss of legal parking space, a garage, or storage in garage would be temporarily suspended until the completion of construction. If conditions remain after the final approval from building safety, decreases can then be filed with preliminary mediation process still available. In fairness, prior to the commencement of construction, property owners would be required to reimburse tenants for acquisition of an annual parking permit, 1 per garage or parking space per unit. As for the other sections of proposed changes to 4400, number 1, the property owner would be entitled to a 7-day pre-notice by tenants of objectionable issues, followed by 3-day notice of intent to file the rent decrease petition. That's putting the landlords on notice, just as it is required for tenants. And number 2, regarding Section 8, Part 2, the dollar decreases, items A, B, F, and H should be construed by the staff hearing examiners under egregious, abnormal, and unprofessional definitions, not merely inconveniences. This goes to the substantial issue of the Golden Gateway case. The same would apply with Section 1, Part A and B, and is to the percentages. Secondly, proposal number 2, and this is regarding the pass-through of costs, which I know the board will not take up until October. There's a great anxiety in the city about this cost. I would like to throw out the following points. 50% of the mandated quake retrofit costs would be passed through to tenants with a maximum of $35 a month, similar to the LA City rule, Los Angeles. Documentation would be short form, as was used in the 1994 quake repair process. The summary process of invoice contract documentation would be required in a summary form. Owner, labor, and management costs would not be included, going to the issue of shared. No floor, no ceiling. That the monthly MAR surcharge would drop off after costs are reimbursed. That if costs are paid in cash, meaning there's no loans involved, no interest would be charged. And if it is financed, the actual out-of-pocket payments would be the basis for the pass-through. Low-income reg fee waivers would be exempt from the pass-through. Annual AGA notice, the annual general adjustment notice, would include the pass-through amount and record the drop-off timeline. I'll stop at that point. As to 4400 in particular, page 7 and page 9 are my 2 comments. As to page 7 regarding mediation, if I could just finish, keep the mediation as is, where it is available in all cases, not simply at the discretion of the administrator. And page 9.
Mr. Johnson, if you can just finish your
Last
sentence.
sentence on page 9 would be under amendment, under the word amendment number 2, we would add number 3, that the landlords and the contractors have a right of response and subpoena witness and documents, not only the petitioners.
Thank you. Thank you, Mr. Johnson.
Thank you.
I have Lori Brown. You have requested 5 minutes. And also following her, Elaine Golden-Gieler, who has also asked for 5 minutes.
Good evening.
Good evening.
Chair, commissioners, and staff. I too was coming tonight to talk about the earthquake retrofit, but I think I'm just going to switch it, and I didn't realize I was asking for 5 minutes, so maybe I could make it shorter. Going back to decreasing tenants' rents when a landlord does construction. I was sitting here contemplating about what happens if I wanted to rewire the building. I'm not going to do it because I'm afraid that that project, even though I get the permits, when I start opening walls, it's going to take a long time, and then I'm going to have to start going into decreasing. And I think that you should be concerned that people, when they're saying that their units aren't up to snuff or the landlords aren't doing anything, I think that there's a big inhibit of people actually being able to do something because of the fears of they're barely making a living on the buildings. And I'm talking about the smaller units. I'm not talking about the larger units. I'm talking about 3 and 4 and 6 units. I spend time at the landlord association meetings, and the tenants, the people who show up there, are elderly. This is not a young population of young people who are buying units. And I think that these people who have had these units for a long time are really trying to take care of their buildings.
Sorry.
I also noticed a lot when people were speaking that it was very difficult to speak when there was chatter. So I'm going to take a step back because it's really difficult to stand here and talk. It's uncomfortable, as the lady said before, and you've seen it. And for 3 minutes just to take the attention. I'm a hardworking person in the city, and I am trying to do my very best for the tenants, for myself, for my family, for my community. And it would be really nice if this board and the landlords felt that we had the information together. As the other gentleman was here, we thought we were going to be talking about the earthquake retrofitting. But when it comes to starting to make decreases, be very cognizant of that people will not be fixing up their units because they are afraid, very much afraid, that that will be the next run-in coming down here to knock on all the windows and all the doors to say, I have dust, I have this, I have that. When we go into buildings, when we go into walls, you have no idea what goes in there. You could rip up a floor and have asbestos, and that comes into all kinds of things, and you don't know that until you go in there. So everybody wants to protect everybody, but they're going to leave the asbestos down there because they're afraid of what's going to happen when a tenant comes running in and saying, wow, you ripped up the floor and there's asbestos underneath, and now, there's a lawsuit on my hands. So I'm just saying to you, be very cognizant of the landlords in this town who are trying to do the right things, who come here to express their concerns and opinions and really want to be heard. We are living in fear out there. We're living in fear because we don't have correct communication. We don't feel that we are heard. As Ms. Golden-Gieler said, she felt that every time a landlord came up here, they lost. That should not be the case. This should be viewed as a place that's fair. And I believe coming in here every night that I come in here to be fair. So thank you for listening to me. Thank you for stopping your time to listen to me. I'm sure I don't have all of the codes down and all of the different processes as I'm trying to learn. I could easily sell my building today to somebody who will demolish it and remove the tenants. That's not my intention. My intention is to keep the building, to save it as a piece of a property that everybody can live in. And if I cannot do the repairs, then that causes a problem for everybody. Thank you.
Thank you, Ms. Brown.
I have a question just related to
For Ms. Brown?
related to Ms. Brown.
Sure.
Thank you.
So, first of all, thank you for speaking here tonight.
Thanks.
You're always very thoughtful, and I think that, we hear what you're saying, and I appreciate it. personally, and I think on behalf of the board. I do have a question for council, which is, how did this confusion about earthquake retrofitting happen? Because from the staff report, it was very clear to me that this wasn't reaching it. And I understand Rosario Perry had sent a letter saying, raising these issues with retrofitting. Was there correspondence with Mr. Perry, or?
No, people, for whatever reasons of their own, reached that conclusion. It's not a rational conclusion, but it seems to have been widespread among a small group of people. But there's nothing that staff did or said that hinted at that.
Okay. So just in the future, if that is what's going on, who would be the best person for members of the Landlord Association to speak to get clarification on whether an agenda item is going to reach something that they're concerned about? Because it seems like a lot of people have gotten very kind of animated about this.
She responded.
I can tell you that when people raised the issue, we did tell them that, and that doesn't seem to have deterred them. So.
Or my concern is that it didn't get back to them.
Oh,
so
Okay, wait, hang on a sec. Do you have any more questions for Ms. Brown?
I can answer that to you. When I walked in and I saw respect and construction-related rent decreases, to me, that also represented what was coming on, because that is construction. Whether construction is mandated by the city or mandated because it needs repairs or mandated because the landlord wants to improve the building, that's where it came in for me.
And did you know that Ms. Condon had responded and said this doesn't reach earthquake retrofitting?
I respect all of you. I don't have any. I have not had coffee with anybody. I don't have conversations with Ms. Condon. I looked at the agenda and looked, and I don't have a building that I thank God that I have to retrofit, but I can tell you that people who have the buildings are very, very concerned because it's costly and they're freaking out.
My concern is really about making sure that people understand that if there is a concern like this and you see it on the agenda, rather than kind of perpetuating a hysteria around an item or a real concern, right? This is a legitimate
Respecting
concern.
construction-related rent decreases to me meant any construction, whether it was something that I wanted to do, whether it was required to do, or a new law that had to be done.
So in the future, I guess my recommendation would be, and this goes to all members of the public, that if there is an item that you think is going to reach a particular issue of concern, like retrofitting, and I know retrofitting is like right at the top of the agenda, please reach out to our information officers or to our staff, because I think even when we set it on the agenda last month, we specifically said this doesn't reach retrofitting. So there seems to be a breakdown in communication, and one of the things that I think all of us care about is improving communication with the landlords.
Then it should have added, except the new retrofitting.
It doesn't apply to
that. It doesn't apply. That's where the confusion came from for me, who is interested in what you do and the laws that are coming up and want to get as much information as I possibly can. Upon looking at that, when I read it, that is what I understood. And when I sat down tonight, and I'm sorry, Mr. Lewis said that it was not, I was happy that it was not on the agenda tonight, okay, and was ready to go home. And then when realized that I think construction, and after Jim spoke, I think it was really important to just, again, reiterate that when a landlord wants to do something or has to do something, that there should be an overall consideration for it.
Thank you, Ms. Brown.
Thank you.
Thank you. Okay, I have Ms. Golden Geeler. You have requested 5 minutes. Whenever you're ready. Because public hearings.
She already gave 5 minutes.
My first comment is you have to be kidding, because anybody who reads this would think it's about retrofitting. And if it's not, why don't you put that in writing? And would you say that under oath? Mr. Lewis? Sir?
If you have make your comments. You have your 5 minutes, but this is not a question-answer period.
I'm just making that as a, I don't know what you call it, but
Point.
statement.
Okay, your point is taken.
He doesn't have to answer, and he won't.
Right, and also for future comments, all comments should be directed to the chair, which is me.
Okay,
And
I'll ask you then,
Thank you.
can we put this under oath? And can we put it in writing that it's not about retrofitting? Because this is a law that was there from 1999, and now all of a sudden it's being changed in 2016 at the time when retrofitting is about to take place. So it appears to anybody logically that that's what it's about.
Ms. Golden-Giller, I do think.
Well, no,
Sorry.
please,
I'll do it.
go ahead. This is your time. Speak, if you would like.
It's hard for me to speak about this because it's very upsetting, and I'm not the only one who's upset. We're stakeholders in this city, and we're being ignored as usual. We should be consulted, and we should be part of the discussion. Instead, we're told what to do at all times, and it's not acceptable. And I think you guys are going to face a legal challenge, and I think we'll win the lawsuit if we file one. Thank you very much.
Thank you, Ms. Golden-Giller. Okay, I have no more chits, requests to speak. However, I have a request. There are several people in queue to have discussion on this matter. And the request was from Commissioner Terosis, who has to leave early. Commissioner Flora and Commissioner Foster, can she jump ahead you? Okay.
Thank you.
Commissioner Terosis.
And this is intrinsically related to my request that we study this process to see if it's possible to address Ms. Golden-Giller.
I'm sorry, if I may just say, before we go on, sorry for the interruption. Public comment has concluded, and now the board will begin deliberation. So continue on.
Okay,
please.
and I do want to, before I give my comments, full disclosure, this item was continued from last month's meeting. This is not a new item. It has now been 2 months that we've had time to consider this. I did ask for input from the public at our last meeting because we were disappointed at the low number of people that came to comment. I am happy to see today stakeholders from both the landlord and tenant community coming to make comments on this item. I also want to say in full disclosure that I've had several conversations outside of this board, outside of being on the dais, with stakeholders in the community who have reached out to me in the intervening period to discuss their thoughts on this item. And I, again, want to say that I welcome any comments from the public, and we all communication with us here is shared with the board, so we have ample time to consider it. As a matter of practice, I do think that when considering large items such as earthquake retrofitting, I am supportive of stakeholder engagement sessions. However, earthquake retrofitting is not what is before us today. And in fact, this ordinance, or excuse me, these regulations have been before us again, like I said, last month, and this is not new. This is not new law. This is not an overreaching of what was previously there. This is simply a streamlining of what was already in effect per our request to simplify the process for both landlords and tenants pertaining to construction-related decrease petitions. And I just wanted to set that stage. I think this is important to us because Los Angeles County, as we know, is facing a housing affordability crisis. And I think this is a situation in which we need to be extremely vigilant in seeing how the law is applied and making sure that it's clear and that it's fair. So I agree with all of the comments on that. One element of an effective housing strategy is to protect existing tenants from displacement. Displacement from their homes, displacements from homes they've been in for years, homes that are affordable to them, because, as you know, there was a high increase in homelessness this year, and if we don't stop the inflow into homelessness, we are not going to solve this region's problems. And that being said, we need to make sure that those people who are at the margins, who are potentially being harassed, as one commenter said, in an effort to perform lots of construction, that those individuals are protected, and also that landlords know what is required of them and that the process is clear and fair. In case you didn't know, average rents for apartments in this county have increased 25% over the past 5 years, while area median income has increased not at all. So I think that that's relevant to this discussion about displacement, and that's relevant to the discussion about making sure that construction, as real estate speculation is on the rise, that we're clear about what needs to be done in construction-related decreases, and that both landlords and tenants have that information available to them. I appreciate that we're incorporating our mediation agreements into the means and methods plan. Again, that was a result of having our neighborhood preservation coordinator and our building and safety department come and speak to us. That had nothing to do with anything pertaining to earthquake retrofitting. This is really simply to better coordinate between city departments and agencies to leverage our collective power so that we don't have landlords and tenants walking from agency to agency to agency and having multiple meetings, so that we have a clear process where everyone's on the same page and we have agencies working together. So for those who didn't know, that's a little bit of the background on that. And I think, like our counsel said, allowing the parties to move more quickly and making mediation more effective, efficiency is really the goal here. In terms of moving to the actual comments on the regulations, I just wanted to say a few things. I agree with our council's recommendation that we add on page 3, section A, within the landlord's knowledge or control to the end of that clause. Also on the definitions under necessary repair and maintenance on page 4, I did have issue with this under section 2, this last clause, or to maintain the property in good repair. I think maintaining the property in good repair is vague and ambiguous, and I would recommend deleting that because I think it's going to be subject to interpretation, and I think that could be construed unfairly. So I would suggest that we say repair or maintenance is necessary if it is required to comply with a government order to comply with a building, housing, or health code, period. And I don't know if anyone wanted to weigh in on that, but I think it's too vague. On page 5, under C1C, sorry, I know that it's a little confusing to follow through here. On when rent decrease is authorized, like Stephen said, construction substantially interferes with the tenant petitioner's ability. I support that. I think we need to be consistent. And then on page 6, at the end of page 6, the notice provision, I noticed that in our previous ordinance we had within 5 working days, and we didn't put a time frame in here. And I think that although we know our current organization is very diligent, who's to say in 10, 20 years from now that this doesn't get reinterpreted and we have a 30-day backlog. So I would like to keep some sort of time period in there. And I suggest that we say after notice to the landlord, comma, within a reasonable time period, but not to exceed 5 business days. I know there was some concern about the 5 working days. Is that a weekend? What is it? I think if you say 5 business days, it's clearly 5 days where the office is open. But staff, please tell me if you think that that's too onerous. And then just quick question for staff. When we say that you're receiving notice of the construction occurring, where are the sources of this information and how diligent are we at following up once we hear about something?
Well, we hear about this in a variety of ways. We may hear about it from the tenants. We may hear about it when the building department issues a permit. Originally, it said the board would send these notices out when a means and methods plan was required. But the city is looking at, they're evaluating the means and methods process. They're going to be making some recommended changes for it. But generally, we any source of information. It could be the building department. It could be somebody who goes by the building and sees the type of work that's going on, or tenants living in the building. So we want it to be as broad as possible where the information could come from. But we are coordinating more with the building department on the permits that are being issued.
Okay, great. That's good to hear. Yeah, again, I just suggest that we either say 5 or not to exceed 10 business days, one of those two.
And to that point, we can certainly do that. I think we could put, either 5 or 10 business days. That was really important when the notice was the point to
Right.
which the decrease would date back. It's not as significant now, but still we want to get the information out as quickly as possible. So I think that would be workable to say within 10 days.
I definitely think that would be great. I'm just looking to see if I had any other concerns. I just want to say overall, I was very impressed with staff's reworking of this. I think that you really took our comments from last month and did a complete overhaul. And I think that the new form is much clearer. And again, this is not pertaining to construction-related decreases for the earthquake retrofitting. That's going to be a separate meeting. And just on the face here of what I'm reading and thinking about how it's going to be applied, I feel comfortable with those few minor changes here.
Thank you very much. Commissioner Flora.
Yeah, first and foremost, since Commissioner Terosis thinks she can just walk up and leave us early, I think we all agree that nobody tells her what happens after. I'm just kidding.
I'm not leaving yet.
I like to tease I love my colleagues, and I especially love to tease Carolyn. First of all, I also want to thank staff for the way you put this together. I really love the side-by-side, mostly because I'm a dummy, and it helps me read it a lot easier, the before and after. That was brilliant. I didn't notice this at first, but I do appreciate Commissioner Terosis bringing this up under on page 4, number 2, necessary repair and maintenance. I completely agree that we should strike or to maintain the property in good repair. I think there's a real danger that could be abused by nefarious landlords out there. And they start getting into aesthetic issues and considering them necessary repairs. I think that becomes a big loophole, and we should make it specifically end at housing or health code. For the exact reasons you just said. I think that next the sentence that comes after the semicolon could really be misused, abused, or misinterpreted. At least I could see it happening. And listen, I think not on everyone's part, but there's been a little bit of obfuscation, particularly with the last bit of theater we saw this evening. But, there could be a case for using the term elective construction, or maybe there's a better term somewhere in here, or maybe the preamble that Mr. Johnson suggested, just so that there's absolutely no way that certain forces can come in here and try to obfuscate and scare people, as I think the last speaker was trying to do. Let me tell our legions of viewers, as well as you in the audience, what is happening here. The last speaker really put on a ridiculous show of theater. And she did so because she wants everybody to worry that the Rent Control Board is really up to something that we're not. She wants to foment a bit of fear. She wants everybody to think that we're trying to keep things from landlords and that they're being forgotten. Let me tell you what's really going on in this city right now and in this region. Tenants that are living with and often are displaced for months at a time from construction-related delays, purposeful chicanery, and stalling to hope you'll take the next buyout. That's what's going on. Those tenants are the ones that are being ignored. And I resent any other implication otherwise. We listen to the landlords that come to speak to us. Most of you are incredibly ideological. Some of you, thankfully, are not, and we hear what you have to say. You've never been a bad apple in my eye. You, Miss Brown, seem like,
Commissioner
in fact,
Flora, you can make your comments not directed at anybody.
well, I'm going to compliment her anyway. I already said the name. Move to strike, but she knows who she is. She seems to represent somebody that really wants to take care of her people, and she brought a very legitimate thought process forward. The ideologues that often come to visit us do not. That said, Commissioner Trosas mentioned the staggering rent increases over the last several years while wages have remained stagnant. There are articles about the incredible rent increases here on the west side and in Santa Monica being written in the New York Times, far, far away, folks. Okay? So landlords continuing to come here and cry poverty when they've got plenty of money to make all kinds of improvements and offer buyouts, it just rings hollow. You sound foolish, and it's embarrassing. And what's really going on, and I know this from my neighbors, and we did get a lot of emails about this as well, and some real horror stories from some constituents that emailed us, is among a particular set of bad apples, hardly anywhere near a majority or even plurality of landlords in Santa Monica, but there are people who really should never be allowed to own a building who are purposely taking plenty of time to let certain construction delays occur, to use that time to offer buyouts, often lowballing tenants. I know for a fact that some of these buyout offers have been accepted half by check and half by cash, so that the buyout averages are not showing up on our new records, so that the buyouts falsely look a little bit low. There's a lot going on out there, and that I want our people in the room and our people viewing us at home to know. This is why this topic is coming up right now. This is not a new provision in our charter, but we are very right in talking about it now because this is the new harassment. You've heard me the last couple of years talking about harassment by way of neglect. You just simply stop fixing things. Most tenants in the city, unfortunately, don't know about rent decrease petitions, and you hope they get sick and tired of it and they move on. This new construction with the new wealth under new ownership who can afford to buy these buildings at exorbitant market prices are coming in, making tenants feel incredibly uncomfortable, making a lot of noise, taking their sweet old time, and that's why we're talking about this.
Hang on
now,
one second.
as for my questions.
Hang on 1 second. Public comment is closed. Commissioner Brown, I'm going to ask that you sit.
Since my
Yes.
name was mentioned in his
This is
discussion,
public comment has been closed.
then
Commissioner
I'm gonna-
Brown.
Can
I
just
ask that you
stop
take
the
your
public
seat.
rant and his
He's in-
insulting at Ms. Golden? I mean, I don't have to sit here and listen to this. This is wrong.
No, you don't. Commissioner Brown, I ask that you have a seat. You're welcome to leave if you choose to do that as well. Public comment has been closed. Sorry for the interruption, Commissioner Flora, if
Yeah.
you'd like.
So on to my question. I've been elected to do this twice. So, you haven't even heard some of my rants. You're kind
Commissioner,
of,
okay, order, please.
All right.
Can we stay on focus? We're talking about item 11B, if you can get back to the point.
So,
please.
yes, here are a couple of my questions. Actually, most of my questions were comments, and I made them. But I did want to ask, and I hate to go there, because of how much we've made about this not being about earthquake retrofit. But I think it even came up a little bit last month, or maybe it was in a private conversation I had with one of you. Naturally, and I would think they would do this, a responsible landlord would probably want to do everything at once. They're going to get their loan, or they're going to get a certain amount of money that they've been saving and do some earthquake retrofit along with some other improvements. Where do we feel confident enough to know when, with what we've gotten here in writing, when it's retrofit and when retrofit is being obfuscated to be used for something else? In other words, I mean, let's face it, a lot of these things are going to be going on at the same time. The retrofits predominantly are related to parking, but if there are other improvements going on in the building, is that something that the permit process would make separate? Would they be separate? Would they need to be separate permits so that if tenants had a problem with construction not related to what the landlords are mandated to do, earthquake retrofit, that it was clear that they still had a case for other construction delays and problems? Do you understand what I'm getting at? I just want to make sure that the tenants will understand that they could still bring a case because of other things going on, because they may be told, well, it's earthquake retrofit. This is all part of the same thing. And they may feel rendered helpless not knowing any better. I'm just curious how we handle that problem.
Mr. Lewis, do you have any comments?
Yes, it's not at all unusual for a case to have a lot of complex facts. Ms. Regalado can speak to this more personally than I can, but we have had cases that I've been aware of in which somebody pulls a permit to do particular work and then they do other work that they didn't get a permit for, or they are doing some of the work appropriately and other work inappropriately. So there's always a factual inquiry as to what is happening and does it give rise to a rent decrease under the regulation. There's no way by regulation, I think, to separate those things out in advance, because the question is always just a factual question of what is happening. Is that responsive to your
question? It's helpful. It's helpful. But I can see this coming, and I think wisely, if I were a property owner and I happened to have a soft story building and I knew I was going to have to put up some steel to reinforce the parking, while I'm at it, I would probably want to be refurbishing a few things here or there, particularly if I'm using, I don't know, the same crew or whatnot. And I just could see this coming up a lot. And less well-meaning landlords or building managers telling tenants, well, you don't have a case here because this is all related to the same construction.
In terms of what the permits provide for, the city has is accounting for that in its earthquake retrofitting ordinance. It's saying that the permits for earthquake retrofitting are for that only. And so there isn't the mixing together of different things in a permit. Somebody may get an earthquake retrofit permit and then do other things for which they didn't get a permit, which would be problematic, and we have seen cases like that. But you can't get an earthquake retrofitting permit as a part of a larger scheme involving a lot of other things.
Right. And I'm sorry, I did have one more question, Mr. Chair. I apologize. I know this is a very long item. Is the means and method plan itself an allowable target for a complaint? Most tenants may not get a look at a means and methods plan, but I imagine they could ask to look at one. And if a means and methods plan does not represent what's actually happening, but there's not really a delay per se, is that a fair target itself, the means and method plan, if what's happening isn't what the building owner said was going to happen?
Well, the means and methods plan itself would not be the basis for a rent reduction. What we would recommend in that circumstance is that they contact code enforcement and inform code enforcement that the means and methods plan is not reflective of what's going on at the property, and they will take a look at that. That's within the domain of the building department and code enforcement. So that's what we would recommend with respect to the means and methods plans.
Thank you. All right. I've taken up plenty of time, and I appreciate your patience.
Thank you, Commissioner Flora. Commissioner Foster.
I'm going to be brief because I think Commissioner Trosis and Commissioner Flora so far have mostly covered a lot of the things I intended to speak about. I'm not going to be redundant. I also thank staff for this, a lot of hard work, tedious hard work. When flaws become apparent, laws are living, flexible, breathing things, and we change them. Times change, circumstances change in communities, and when they do, we address them with changes to the regulation that we hope are helpful to the people who elected us. Defining the terms is exactly what this is about. Vagaries are all too often used, and this goes a long way to remedy that. Appreciate that. I'm very pleased with the change on page 6 that the recommendation to eliminate the 24-hour interruption threshold was carried out because, as we discussed last month, that can be abused, and I appreciate that being included. That being said, I completely support and would entertain making a motion to pass this item.
Okay, there's a couple more speakers. We are going to skip Commissioner Trosis and Commissioner Phyllis.
So mine's very quick. I applaud staff for a very thorough report, as usual. And I think, in particular, 2 of the proposed amendments of my colleagues are well taken. Number 1, the clarification as to the time limit. I think 5 days is better because more. More prompt notice. And I really appreciate Commissioner Flora's recommendation, which speaks to, I think, some of the concerns of landlords, that this is for voluntary repairs. This is for non-compulsory repairs. I see, looks like Ms. Condon has a reaction to that. I like the way that sounds. If there's a reason why you think why we shouldn't, tell us.
Well, the only thing I would say is we're following the Golden Gateway decision, Golden Gateway Center decision, and we've made an exception for what work would not be subject to this process, and that's on page 6. What is that? C2, where it says the board may not grant a rent decrease under subparagraphs A or B of the preceding
6.
paragraph for unavoidable construction impacts caused by necessary repair or maintenance unless the construction is carried out in an unreasonable manner or the construction takes an unreasonably long time to complete. So those are concepts that come directly from the Golden Gateway case.
And you think those speak to their concerns because seismic retrofitting is not unavoidable?
Right, and it will be required. Let me see.
And there still shouldn't be a loophole that this wouldn't apply if seismic retrofitting is carried out in an unreasonable manner.
Right. Right.
Okay. So I'm okay with that.
Okay.
Anything else?
No. So I'd move the item with just Commissioner Terosis's clarification. And obviously it's part of the public record, to people who have concerns about this, it is part of the public record, our discussion about the intention of the board with regard to earthquake retrofitting. To the extent that there's any ambiguity in the regulations, I have no doubt that the transcript of this proceeding will be trotted out.
Okay, so I do have a couple of comments to make. I was going to mention about putting a specific date. I think Commissioner Trosis made a good point that who knows down the road, years, decades down the road. I think clarifying with a day's notice is a good idea. And I think that the 5 days, as Commissioner Phyllis has mentioned, would be good in this case. The one thing I wanted clarification on was page 4. The definitions, B2. No. Mr. Lewis, I believe you indicated that the last clause, or to maintain the property in good repair, came from a ruling or some other site. And am I mistaken there?
It didn't specifically come from a ruling, but it is my view that without that, this is potentially too restrictive. I think because she deals with the issue more up close than I do. If Ms. Regalado can speak to that, she can probably provide a little bit more background. As I mentioned in my staff report, there was a lot of discussion among various city departments and also among staff. And this phrase was very important to the hearings department based upon their experience over decades of actually implementing this law. And so I think it's important to hear from Ms. Regalado with the chair's.
Ms. Regalado, do you have a comment to make?
Sure. I mean, this is the standard that we employ in regular decrease decisions, as well as the way that we've interpreted in our construction decrease decisions. And we're taking a page from this Golden Gateway Center case that everyone's talking about tonight, where the owner undertook repairs to balconies, anticipating that they may become unsafe. So there was no code violation, there was no government order to repair the balconies, but the owner undertook to repair them in advance of them becoming unsafe to protect the tenants. And so that was the reason that we felt that this language should be included in this definition.
Okay, my comment about it is I'm still left with it as written being a little vague and ambiguous as to what good repair means. I think that not having that clause in there, though, is also too rigid. So I don't know if there is something in the middle that we could craft that is maybe gives more direction to, or at least a definition as to what is meant by property in good repair, to give more guidance prospectively. Yes.
Well, one of the standards that we refer to is under 1805E. Housing services are defined to include repairs and maintenance, and so I think you can look at it in those terms as opposed to say keeping a property in good condition, which might be something that brings it up to a higher level of use for a tenant, as opposed to just basic repairs and maintenance that to maintain the standard of use of an object or the unit.
I would also just, if I may, just add that there is, it's not unusual for a definition or a statute that's not a definition to include a word like reasonable, for example, which is subject to interpretation. It is the job of the hearing examiner to apply laws in factual situations that arise. It's the job of the board, if a party disagrees with the hearing examiner's decision, to review that based upon its understanding of what the purpose of the law is. The idea that it's possible to craft statutory language that encompasses everything with a laser-like focus on one or the other side of the fence is probably not, that's probably not a worthwhile pursuit. My recommendation, given in the absence of some other language that accomplishes what we want to accomplish here, given that this language is based upon the couple decades of experience that the hearings department actually has in implementing the law, and that this is in conformity with what we actually do. This is not a new concept. My recommendation, unless again there is some statutory language that the board can craft tonight, would be to enact that language as it is. If it's necessary to refine it further, this is not being carved into stone. Obviously, it's a regulation that can be changed. But I think that the regulation, that definition is more defensible precisely because of its inclusiveness than it would be if that were not there and it were interpreted as being unduly restrictive.
Can I speak to the recommendation?
Okay. You go, sure, please, go ahead.
So I'm very persuaded by that. I also think it's bad practice to, unless it's, really like a line edit, like what we're talking about in terms of 5 days, to draft policy from the dais. I just don't think that it's necessary. Often can lead to results that are unintended. I find it much more helpful if we have a more deliberative process. So I would be very comfortable with taking council's approach, and then to the extent that, you know, we have continuing concerns about it, consider potential hyper-focused amendments. We could even direct staff to come back next month with a very hyper-focused amendment to the regulation in light of, you know, these specific deliberations. But I think we need to get this passed tonight, and I think that we should not be drafting policy, or we should not be drafting from the dais.
Okay, thank you for your comments. I have a couple of other issues that I'd like cleared up. Let's see, I addressed that. The suggestion that Mr. Johnson made in regard to a preamble, I don't know if a preamble is the right thing, but perhaps, or what does council think about, to make this very clear, that the retrofitting issue be stated in the definitions, where it makes clear that this does not apply to that.
There are hundreds, if not thousands, of things that would not be included because they're reasonable and necessary. If once the board embarks down the path of including specific things that are not included, that suggests that other things that are not specified are included. That's not a good idea from a drafting perspective.
Mm-hmm. Okay, very well said. Thank you.
Is there a motion on the table?
Well, I'm still talking.
I'm sorry.
Where, Commissioner Flora, if you could remind me, where was your consideration of, or what did you consider in putting in the non-compulsory repairs? What section were you referring to?
It was this very same page 4 item that we've been discussing, but I'm a bit persuaded by staff. I was looking at it from the lens of how a irresponsible landlord might try to consider something elective but it needs to be done because of good repair, and that was my worry. But I'm persuaded by some of these arguments of not including certain things or disqualifying certain things that invites other things to automatically be included, and I was persuaded by that. So
okay,
yeah.
Thank you. All right, very good. I have Commissioner Flora on cue.
Yeah, and I apologize again. What happened was my commentary notes got mixed in with my questions, and I did have another question that was important to me. I remember last month being very excited over the prospect of us now allowing attorneys to represent folks in hearings, particularly in my thinking for the tenants to have somebody to guide them through the process. As I think about it this month, I'm thinking, which of the two parties is most likely to be able to afford or probably already has an attorney? My guess is 80% of the time it's going to be the landlords. So can you speak a little bit to that? You seem not, council did not seem too worried earlier because obviously our fantastic hearing staff would be able to sort of even the playing field. But am I wrong in assuming that more often than not, if one party is going to have a landlord and one party isn't, it's going to be the landlords?
Yes, that is correct. I just want to clarify that this concerns not the presence of counsel at hearing, which is permissible already in any event. There's no suggestion to change that. This is just the participation of counsel in mediations. And mediations happen in a variety of ways, including by telephone or with the parties in separate rooms and not talking directly to each other.
Great.
And it's been staff's experience that having lawyers participate in the mediation is often beneficial because it helps temper their own clients' expectations about what they can get out of
For
the process.
mediations. Thank you for the
mediation,
reminder.
right. Yeah.
I'm sorry.
Okay, thank you. Commissioner Phyllis.
I'm ready to move with the 5-day amendment as I had previously.
Okay, can you state
So
the full
I
motion?
move to accept staff's recommendations with the single amendment that I don't know what section it is.
It's on page 7, D, 7, yeah, D, section D. But there are a couple of other changes.
No,
too.
sections. Wait, E.
No, it was
Where?
it was page 6,
Notice to the
D.
landlord within-
6D.
New subdivision D.
New subdivision D. Right. To add that to the 5-day
Right.
limitation. That's it.
Okay.
Mr. Lewis suggested a couple.
Yep. Does the board not want to include substantially interferes with and within the knowledge and control of the of the landlord? So we should add those as well.
Yes, please.
And can you, for the record, can you
Yes.
state where that is exactly?
Under subdivision A purpose, at the end of the existing proposed language, it would say, as a result of construction, comma, within the landlord's knowledge or control. And in proposed new, I'm sorry?
Page 3A, the last, right after the last sentence.
And then in proposed new subdivision C, which is on page 5, C1 subparagraph C with a capital C, insert the word substantially between the words construction and interferes. So it would read construction substantially interferes with the tenant's petitioner's ability, etc.
So those 3 changes.
Okay, so I amend the motion to have section D to include the 5-day limitation and then to adopt the recommendations of staff as set forth just now with regard to the substantial modifier.
Just a point of clarification for your motion, 5-day, did you mean 5 business days or 5 calendar days?
Calendar.
Oh.
Or business. Business. Sorry, business.
Okay.
Sorry.
5 business days.
Whoa.
Okay, there's been a first. Is there a second to that motion?
Second.
First and a second. Any other deliberation? Hearing none, we'll take a roll call vote.
Commissioner Foster.
Yes.
Commissioner Flora.
Yes.
Commissioner Phyllis.
Yes.
And Commissioner Duran.
Yes.
Motion carries.
Okay, that is it for 11B. Moving on to, where are we getting?
Adjournment. Move
Number
to adjourn.
16. There'd been a motion to movement to adjourn. Is there a second?
Second.
Okay, all in favor? Aye. Any opposed? Wait, all in favor? I heard one aye.
Aye.
Okay. Any opposed? Okay, this is adjourned. Thank you. Good evening.
We're staying for a sleepover.